Good afternoon and welcome to Ascot Lloyd and Freeth's first series of joint live webinar events. Thank you for joining us today. My name is David Malloy and I'm your host. Today we want to help answer some of your questions about being an executor to help you be more prepared. Before we start, a few formalities. Today is live, so we've done that so we can take questions throughout the event. Now there's a small box which says Q&A on the bottom of your screen. If you would like to, please write your questions in there and we aim to answer as many as we can at the end of the panel discussion. Those which don't get answered, or the answers to the questions that we do manage to answer, we will send out as well to our guests today. So you'll get a copy after the event, we'll send out the details. We'll also send you a recording of today's webinar as well. So if you'd like to share it with other people or just look back on it yourselves, there'll be a link to the recording so you'll be able to watch it again. We'll also be putting questions out to you as our audience, so a little bit of audience participation today. There are 3 poll questions that I will flag during the panel discussions, and we'll need your input on those, so I'll explain those as and when we get to them. So a little bit about our companies today. So Freeths are a top 50 law firm with 13 offices spread across the UK and over 200 partners and directors. Their family wealth practice is ranked as one of the top legal practices in the UK for wills, trusts, tax, probate and court of protection advice. They advise private clients, individuals, business owners on a range of contentious and non-contentious wealth preservation matters ranging from 500,000 to over 200 million. Ascot Lloyd, we are one of the UK's fastest growing national independent financial advisory firms. We have a regional and local presence across the UK and have more than 130 fully employed independent financial advisors. We look after over 8 billion of our clients' wealth. We hope you find the next 45 minutes informative and helpful. Becoming an executor, or indeed deciding on who should look after your wealth, is such an important thing, but it is often a decision that's reached through a short informal conversation over a meal or a glass of wine with loved ones. There's a lot to consider to ensure that things are put in that fulfill your wishes. Indeed, it can be a time when legal complexities come to the fore at the same time as making important financial decisions, and family emotions can also be running high. So let's look at our panelists. I'm going to introduce our panelists today. There are 3 of them. I'm going to start with Mark. Mark Rodgers is an independent financial advisor at Ascot Lloyd. Mark began in financial services a little over 25 years ago, so he's seen most of the market and regulatory changes during that time. Mark joined Ascot Lloyd as an independent financial advisor a little over 5 years ago. Mark has advised on both corporate clients during his time, along with personal individuals and their families. Mark's areas of expertise include investment planning, retirement advice both pre and post, along with tax matters such as inheritance tax, ensuring both individuals and their families are protected against unforeseen life events. Sally Goodger is the director at Freeths, Wills, Trusts and Inheritance Tax Disputes Team. Based in Oxford, Sally acts for individuals who are executors, beneficiaries, trustees, attorneys, administrators and court-appointed deputies, dealing with a wide variety of contested matters, including executor disputes, will validity claims, inheritance tax claims, trust disputes, and mental capacity issues. And finally, Charlotte. Charlotte Digby is the director of Freeth's Trust, Estate and Tax Team. Charlotte specialises in the preparation of wills for high net worth individuals and deals with complex estate administration matters. Charlotte is a member of the Society of Trusts and Estate Practitioners and has achieved additional accreditation for advanced will preparation. So good afternoon, panel. Let's start with a fairly straightforward question. This one's going to go to you, Sally. So why is it important for people to make arrangements for their assets following death? And why should they give full consideration when choosing the right executor for the job?
Thank you, David. Hello, everybody. Good afternoon. Good question. Thank you. Documenting your testamentary intentions in a will during lifetime means that upon death, your assets will pass to your chosen beneficiaries, subject, of course, to any claims against your estate or will validity challenges. An important part of preparing a will and getting your affairs in order is choosing an executor. We'll hear this afternoon that getting it right should mean that your estate will be dealt with smoothly and as cost effectively as possible. I think we all want to avoid a situation where our hard-earned money is spent on lawyers sorting out issues which could have been avoided had you sought the right advice as to your will and financial affairs during lifetime. So if you're appointed as an executor in a will, Charlotte, what are the different options for acting?
Yeah, so good afternoon, everybody. So this is a really good question, because lots of people do think that if they're appointed in a will as an executor, that the only choice they have is to take up that role and act in the estate administration. But executors do actually have different options available to them. So one of these options is something called power reserved, which means that there is a postponement of your executor's right to obtain probate and act in the estate administration. So this might be suitable for somebody who perhaps doesn't want to act or can't act right now in dealing with the estate administration, but doesn't want to completely give up their right to do so in the future. So if they need to step in at a later date, they can do so, and then they can apply to the court to become involved and deal with the estate administration. If you are faced with somebody who perhaps doesn't want to act at all because perhaps they're unwell, it's just not the right time in their lives, or they perhaps feel that it's a bit too beyond them to act as the executor in the estate, they can do something called renunciation. So that's actually relinquishing their right to act in the estate administration completely. So they sign a deed of renunciation and that ends their involvement. Crucially, they can't sign a renunciation if they have already dealt with some estate administration aspects. So if they've already got involved with perhaps selling some assets or dealing with asset holders or dealing with settling liabilities, that will result in a loss of a right to renounce. And then obviously you might just get somebody who really wants to deal with the estate administration and they've been appointed as executor in the will, so then they can move forward and take those steps. If I could just bounce it back to you though, Sally, and ask what situations are there where you perhaps can't act as an executor, or what are some of the reasons that you might perhaps not want to take up your role?
Okay, thanks, Charlotte. Yeah, I mean, I think the first thing to think about here is that an executor must have capacity to act. So an executor can't be a minor, you need to be 18. You have to have mental capacity to take up the job. You can't be bankrupt or insolvent, and you can't be in prison. Providing that they don't apply to you, you also need to be willing to act. And you've touched upon this, Charlotte, but there may be circumstances where it's just not appropriate for you to take office as an executor. For example, illness. It might just be too much for you to deal with. It's quite an onerous appointment, and some people could be worried that they'll be given their other commitments through work or other things. They just don't have the time to give to the administration to bring it to a conclusion in a timely fashion. Also, it might just be impractical. If you lived in a different country, so if you lived overseas, been an executor, it probably wouldn't be practical. It'd be a lot harder job to complete. So again, you might think it's probably not the job for you. Also, you get situations where an executor's got doubts as to the validity of the will, and that may mean that they don't want to be involved and they'd rather somebody else take the job on their behalf. Also, an executor might be concerned that there are insufficient funds in the estate. So again, could be a difficult estate to administer, and they may decide that they don't want to take up the office. Another thing is where there are potential claims for financial provision under the 1975 Act. If you're an executor but you're also a potential claimant against the estate, you've got a situation of conflict, and it probably wouldn't be a good idea to take up the office of executor in that situation. The other thing to bear in mind is that if you've got more than one executor, they have to act in agreement with each other. They must act promptly and impartially, and they cannot act unilaterally. So they have to be pretty certain that if there are co-executors, that they will be able to get on with each other and bring the administration to a smooth conclusion. So bar all that I've mentioned, again, an executor may be quite happy to get on with the job. And, you know, if that's the case, that's brilliant. Now I've got a question for Mark, if I can bring you in here. how do you believe a client's professional expert should come together to assist executors in their duties?
Thanks, Elaine. Again, good afternoon to everybody. I think it's a really valid point that the executor's role, I think, as you and Charlotte have just said, is quite onerous, or it can be onerous. And I think it's really important that all professionals, whether that be accountants, financial advisors, lawyers, solicitors, I think we all really need to use our specialist resource and communicate that with the executor, and really offer a really packaged service where we're really enhancing the experience and diluting the pressures on the executor by sharing all of our knowledge. I think probably a good time now. David mentioned about some polls today, so if I could hand back to David to ask poll question number 1.
Thank you, Mark. So we said about audience participation today. So this is our first poll question. So it should come up on your screen. So the question is, how much thought have you given to choosing your executor? You have an answer 1, which is none, answer 2, a bit, or answer 3, a lot. So if you could tick the one that's relevant to you and then just cross the box in the top right-hand corner. Whilst you're doing that, I'll just sum up my thoughts from the discussion that we've just had, and there's a slide that's coming up as well now. So the key things I've got from there are, would you, or who should be your executor? So age, health, etc. are all things that you should take into account, and why some people shouldn't act. My own personal experience, I have an identical twin brother who lives in Brisbane in Australia. Now, my first will, when we both had young families, he was an executor. I absolutely believe he was the right person to be there. Should anything happen to me, he would exactly know what to do with my children and would know what I would have wanted. Now, we're both very competitive, and I absolutely expect to outlive him. So right now, he's probably not the best executor for my will. And again, that's a common thing we find when we're discussing things like who are your executors, and having someone your same age, if you're expecting to live a long and healthy life, may not be the best person to be your executor. And the other point that was raised from Mark, and I think from Sally, co-executors and professionals supporting those executors. The co-executor, if they've got a different skill or a different interest, again, that can be quite useful. But having those people as well, just making sure that there's a good fit, I think is really, really important. So let's have a look at the results from the poll. So if we can pull that up on the screen, please. So a lot, so that's quite good. So almost half of you have said that actually you have given quite a lot of thought to who the executors should be. So well done, audience, today. Thank you very much for that. And again, we'll send out these results as well, so you can see those if you'd like to. So I'm going to move on now. This is a question for Charlotte, and it really comes on from what we've been discussing. Could you tell us about the duties and risks of acting as an executor if you decide to take up that role?
Yes, so the position of an executor does carry with it quite serious responsibility to administer the deceased estate correctly. And failure by an executor to carry out their duties can actually give rise to personal liability. So that's a liability that's paid by you personally as the executor rather than being paid from the estate assets. So it's quite a big undertaking to take it all on. The duties that you have as an executor are very wide-ranging. So at the beginning, you'll be looking at carrying out things like obtaining the last original will and any codicils that go with that, arranging to register the death, and making arrangements for the funeral, and making sure that everybody who needs to be invited is invited and all the arrangements made, which can be quite a contentious issue at times. And then the next stage you'll want to move on to is valuing the deceased assets and working out what the liabilities of the estate are. The liabilities are quite a crucial one, because if you don't take account of all the liabilities, then you can actually be personally liable as executor if you haven't taken reasonable steps to do so and make sure those liabilities are paid off. The big one that we're most all familiar with is making sure that you've reported all your tax reporting to HMRC. So inheritance tax reporting is obviously the main one, but there's also capital gains tax reporting and income tax reporting that executors have a duty to deal with. So all of that carries with it quite hefty personal responsibility if you get it wrong or haven't made your best endeavours to research all of the assets of the estate and carry out all the reporting correctly. And then obviously if you're lucky enough to have a will and you've got beneficiaries named in there, then one of your duties as executor is to locate all the beneficiaries and any legatees that are mentioned in the will, to make sure that they get given to them what has been left in the will. If you don't have a will and it's being administered under the intestacy rules, then you still have that duty as administrator to locate the beneficiaries that are entitled. So there's a lot of duties in there, and as I said at the beginning, if you don't carry out those duties, then you can be personally liable as an executor. Sally, if I could just bring you in again here, because it would be good to hear about any cases you've dealt with where perhaps executors haven't stuck to their duties and adhered to the rules.
Yeah, thank you, Charlotte. I've got a couple of examples which stick with me, to be honest with you. One case that we've recently, I acted for an executor. He was a sole executor. He was administering a great aunt's estate. He wasn't a beneficiary under the will. Other family members were beneficiaries. He collected in the assets. I think he sold a property, but then what he did prior to distribution was to invest the estate funds in pens. So he bought tens of thousands of pounds worth of pens. His idea being that he would resell them at a profit, so as to make some money for the beneficiaries. Now, possibly not the wisest investment to make, one that we wouldn't have recommended had he mentioned it to us before he did it. I'd like to point out that he did do it before we ever spoke to him. The job had already been done by the time it came to me. But what he was trying to do was enhance the value of the estate assets, and what he'd misunderstood were his duties. It's not the duty of an executor to enhance the value of the estate assets. He should collect them in, pay the liabilities and distribute what's left. So I think, he had the best intention, but it was misplaced, to say the least, and could potentially get him into quite some difficulty and face personal liability if he then fails to resell the pens for at least the amount that he bought them for. So words the wise there to just distribute the monies once you've got it. Don't do anything else with it subject to any claims. Another example I can give is where I acted for 3 executors of a homemade will, and there was a 4th executor as well, so 4 executors named in the will, and they all took the grant. Within the time of the administration they fell out, so I ended up acting for 3, as I say, and they fell out with the 4th executor with regard to the interpretation of one of the terms in the will, and this related to whether or not a legacy passed to the 4th executor. And remember, it was a homemade will, and this was where the root of the problem was. The deceased hadn't taken professional advice. If she had have done, there's a very good chance that there wouldn't have been a dispute at all. But as it turned out, we ended up in a 3-day trial in Bristol, and the costs came out of the estate. So, really difficult, because, had they sought the advice, had the testator sought the advice during lifetime, I imagine that probably wouldn't have crossed my desk. And hopefully people will get the right advice so that I don't see cases like that. Just thinking then, with that in mind, Charlotte, how can a testator avoid potential difficulties at the outset?
Yeah, so you've touched on the big one there, Sally, of the homemade will. So really, to avoid going to Bristol court with you and ending up in a trial, you should seek professional advice. Lots of homemade wills make lawyers most of their money, and you want to avoid that at all costs. So going to see your solicitor and making sure that you have your will drawn up professionally with someone who's qualified to do so, because they'll be able to give you the correct advice. And also, when you go to see your solicitor, they're probably going to talk to you about your executors, or they should be talking to you about your executors, and they will go through with you how to choose your executors. So the things that you might want to think about are perhaps the current family dynamics that you have. So if you've got 2 children, for example, who you already know don't really get on with each other, then it's probably not going to be a good idea to appoint them both to act as your executor, because they've got to get on and make the decisions together. And if there's already a family dispute, then that's probably not going to turn out that well, and they're unlikely to be able to agree after you've died, especially if there's some fun, money in point. Also to think about characteristics of the people that you're appointing as your executors. So you might have people who you think you would like to appoint as your executor, but they may not be very financially astute, or they might just have some difficulty dealing with administrative tasks. Dealing with estate administration is quite administrative, and you have to be quite organised to do it. So perhaps if you've got people who you're thinking about who don't fit the bill with those characteristics, then you might want to avoid appointing them in your will. Keeping it under regular review. So if you appointed executors 20 years ago, their lives may have changed dramatically. So they may now not be the most suitable people to act as your executors. And when I think about that, the most common one is age. So some people might have their parents in there as executors because that was appropriate at the time, but now they've moved on, and their parents have got elderly and they might not be able to take on the job. And then if you really want to appoint your children or family members as executors, but you don't think they've got necessarily the best characteristics and they might need some help along the way, then you could consider appointing alongside them a professional executor. So that could be a financial advisor, an accountant, or a lawyer, and they would be able to assist your other executors by working together and offering their skills and knowledge to help the estate administration move along. So all of those things coupled together are really great things to be thinking about to avoid any potential difficulties in the long run. I think David's going to come in now to do our next.
Thank you, Charlotte. So we've got another poll. So this is poll 2. So again, I'm just waiting for that to come up onto the screen. When did you last review your will? So again, this is one for the audience to give us an understanding of how well you're doing with these. So the answers: answer 1, within the last year; 2, within the last 5 years; 3, within the last 10 years; and 4, I haven't reviewed my will. So just while you're doing the same as before, if you can tick the box that's relevant to you, I'll just sum up my take again. So I think the types and skills that an executor might need, I think that's again really important. That when you're looking at your executors, if you've got 2 people who are very good in one particular area, I've been an executor. I was asked to be an executor because of the fact that I work in finance, and it would help. The other person who's an executor in my case was much more a long-term friend and more about the emotional and that side of things, and knew the person and what they would want to happen with things as well. So we worked very well together, and it was a good partnership. Personal liabilities of an executor, that's a really interesting one. People kind of go into this, as we mentioned right at the start. You feel honoured and very privileged to be asked to be an executor for somebody. So you kind of say yes, and in some cases that can be, there can be situations where you could become liable. So again, it's important that you go in with an open mind and you look at these things fully. And the case study is always good to have a case study because it does bring these things to life. I'm sure that our panelists, all of them, could give you a number of situations where it's either gone incredibly well or where there has been a situation where it's just not worked. And again, that was one of the reasons for talking to you today, was to just give you some food for thought around these aspects of executors. So if you have a look at the poll, let's have a look at the response to that one. So within the last 5 years, again, 42%. So that is actually quite good again. So well done, our guests today. That's pretty good. It's nice to know that people are reviewing their wills. I don't think there's really a hard and fast. We just encourage people when there's a life situation change or what have you, just to make sure that you do keep it up to date. And that's something that your financial planner or your legal representative or advisor can help you with. Okay, let's have a look at another question then. So this one's for Sally, and this is where, so can you tell me when it's too late, when you have an executor who isn't dealing with the estate as they should be? So what happens when it goes wrong? And that's one for you, Sally.
Okay, thanks, David. Yeah, it happens all too often, I'm afraid. You've got an executor in place, and for whatever reason, the estate administration just isn't going as smoothly as it probably should do. And an executor can be removed, okay? They're not in it forever if the circumstances which makes it appropriate for them to be removed from office. Now, an executor can be removed by consent, so you could seek the executor's agreement. If that's not forthcoming, then it's possible to apply to court for an order to remove them. Now, in order to do that, you need a new executor to take up the position. When the application is made to court, you need someone that's willing to take on the job and bring the administration to a close. But it is possible to get that order from the court. In terms of making that application, it's costly, it's time consuming, it's very stressful. So best avoided if at all possible. And if you find yourself in a situation where you're asking the court to remove an executor and appoint a new one, then what the court will have as a paramount consideration is the welfare of the beneficiaries. But the court will also give quite a lot of consideration to the fact that the testator actually chose their executors and chose them for a reason. So it's a high hurdle to remove an executor. There's got to be pretty good reasons why it's appropriate to remove them and put someone else in place. And of course the costs, which I've touched upon, it's expensive, and the courts and how they're ordered to be paid is within the discretion of the court. An executor who's acted unreasonably in the eyes of the court can find themselves personally liable to pay the cost of the application for their removal. In other situations, the cost may come out of the estate. So there's no hard and fast rule, it is the court's discretion. I'd like to bring Mark back in now if I can. And I'm just thinking, Mark, how important is it for executors to understand the underlying investments in an estate prior to taking any actions?
Thanks, Sally. I think it's another example of another burden for the executor, something else for them to consider. And I think Charlotte alluded to something earlier on where we were talking about taxation matters in particular. So I've seen a lot of, not a lot, a good few examples of where the executor has kind of made rapid encashments of investments with the best intentions, really, to try and speed up the process of distribution back to the beneficiaries. Probably the clients I've been dealing with fully understand how their investments work. They've had a number of reviews over many, many years. And we are expecting an executor to kind of pick up a piece of paper, if you like, and fully understand everything immediately. I think when we're looking at encashment, the real implications are inadvertently causing a tax consequence, whether that be income tax, whether that be capital gains tax, whether that be inheritance tax, measures that don't really get done correctly. Losing things like the tax-free status of an ISA wrapper. All of these really need careful understanding by the executor before they look to encash. So I think I've got a question back to Charlotte here, and we've talked a lot about wills and executorships. What would be your top tips, Charlotte, when making a will?
Yes, so my first top tip would be to review it regularly, which we've seen that quite a lot of our attendees today currently do. So we recommend every 3 to 5 years, or if you've had a particular life change. So marriage actually revokes a will if you haven't got a pre-existing clause in your existing will to say that it shouldn't. So if you have got married and you haven't reviewed your existing will, then it's a good idea to go and see your solicitor. Also, if you've had children, you've got to think about perhaps guardianship appointments in your will if you have minor children, and also about making provision for them under your will. And if you've had a recent bereavement and you're coming up to receive some inheritance into your estate, then it's a good idea to go and see both your solicitor and your financial advisor, because obviously an injection of money into your estate is going to affect your inheritance tax planning and might even change or throw up some changes that you should make to your existing will. And also to review the will if there's been any changes to tax legislation. Obviously, inheritance tax hasn't changed massively over a number of years, but we're going into a period of uncertainty. So it could be that there's changes, the government make changes to tax legislation. A few years ago, there was the introduction of something called the residence nil rate band, which is an additional tax allowance for people. And actually, it's important, if you haven't reviewed your will since that particular change came into force, then it's a good idea to do so, because there could be things that you need to do to your existing will to make sure that it's more tax efficient for your estate. And then also keeping a good, accurate, up-to-date record of your assets and liabilities with your will. So when you go and see your financial advisor, making sure that it's a joined up approach with your solicitor, so that it's all kept with your existing will. And that's going to make your executors' lives a lot easier, because they have to know what your assets and liabilities are, value them, and report everything to HMRC. So that documentation is going to be really incredibly useful to them. And making accurate records of your lifetime gifting. So lifetime gifting can have an impact upon your estate for inheritance tax purposes. So making sure that you keep an accurate record of what you're giving away and when you're giving it away, who you're giving it away to, is going to be really useful to your executors, because again, they have to report a lot of your gifting to HMRC when they're carrying out their duties. So yeah, those would be my sort of top tips. But Mark, how do you interact with executors when they're dealing with estates or pre-dealing with estates, and what do you think the benefits are to them and the estate in the long run?
Thanks, Charlotte. I think it's something I'm becoming more aware of now, and offering more of my time to actually deal with executors. I think historically the dealings I've had with the executors have kind of been after the event, so after a bereavement. I think for an executor to have a pre-established relationship with myself during lifetime, essentially, is far more beneficial. We've talked earlier on about working together as professionals to ease the burden on the executors. And I think if we've established a relationship prior to bereavement, that's going to make the executor feel a little bit more confident when dealing with the estate. So it's something I'm really promoting with my clients at the moment, is sitting down and having some form of contact and relationship with the executor. If that's not possible, just simple matters such as having the executors having my email address, a contact telephone number, and really doing everything to kind of make this process as straightforward as possible. I think there's a real benefit in working together between ourselves and the clients and the executors, and that is having that meeting when the will's first drawn up or when the will is reviewed. It's a good time for all parties to come together and ensure that we all know our responsibilities. You know, I think it's important, as you know, just to stress again the pressures on the executors to understand everything that the clients have actually got of mine. And as we're demonstrating today, remote meetings are now becoming more and more prevalent. I'm doing many of my annual review meetings, certainly over media like this, and there'd be no trouble at all with the client's permission for the executor to dial in and get a greater understanding of the complexities of finance. So it's something I'm really wanting to take forward and deal with executors an awful lot more, Charlotte.
Excellent. Thank you, Charlotte. Thank you, Mark. So we have our final poll question now. And this really comes off the back of the discussion that we've just had and the points Mark's made. How many of our guests today have introduced their financial advisor to their beneficiaries or executors? And again, simple answers, yes, no, or planning to. So same as before, if you wouldn't mind answering that one and then clicking the close button at the top. Just a key points slide again. So the things I've taken away from this part, the top tips regarding will reviews. I think that's really important, some really important information. There's some good points and some top tips. And again, you'll be able to see those when we send the details out. The importance of the executor knowing your assets and investments. I've been in the situation myself where, as I mentioned before, I've been an executor, and you have that moral responsibility, but you have to be certain. So unfortunately, it did involve rummaging around the deceased's kind of house, looking for those share certificates that we're confident they existed. Premium bonds are also a good one, which sometimes get missed. So having that snapshot or an idea of where the wealth is, if you know you're an executor, is really quite important. And finally, the other one I've taken away from that is involving a trusted advisor, your trusted advisor, the people who help you with your finances or with your legal representative at an early stage. You might think, well, you would say that anyway, but it is part of why we've put on today to just give you that bit of guidance. We've seen it go horribly wrong as advisors. We've seen where preparation hasn't been made, and we've also seen the benefits and how much, either from a legal or an advisory side, you can help that client if the preparation is done at an early stage. So let's have a look at the response to this one. So no, and that is, again, comes back to why we're talking to you today. So it's not uncommon at all that people haven't thought about introducing their advisor or putting their financial details with their will and what have you. So as I say, that was kind of what our thinking was when we started thinking about how we should help educate and talk about these things. So thank you very much for that. What we're going to do now, we're going to try and make sure that we don't run over on time, but as I've said, we're happy to take questions. We've had some prior to, and we've got questions coming in on the Q&A. So I'm going to start asking some of the panelists some questions now. Sally, if I can start with you first. What should executors do if the beneficiaries are in dispute?
So thank you, David. If an executor finds themselves in a situation where the beneficiaries are in dispute with each other, then the executor should remain neutral. So they shouldn't be taking sides. They should sit back and let the beneficiaries sort out the dispute. They shouldn't be making any distributions until the dispute has been sorted out. They are obliged to provide information and documentation regarding the estate to the beneficiaries and or their legal representatives if it's requested, to help them resolve the dispute. What an executor needs to do, however, if there is a dispute going on, I say they need to remain neutral and not distribute, but what they must do is preserve the estate assets. So there may be certain steps that need to be taken to preserve the estate assets during that time, and that's fine, but what they shouldn't be doing is making distributions until they know who to distribute it to, because usually the argument is about who's getting what, because Absolutely. The beneficiaries don't like what the will says.
Yeah, completely understand that. Okay, one for you now, Charlotte, and this one's come in. Can I have as many executors as I like?
So this is a good question, because only 4 can actually prove your will and act in the estate administration. So no more than 4, I would say. And some people will tend to go for 1 sometimes. And what I say about that is it can present complexities if they themselves pass away and your estate administration isn't complete, or if they perhaps lose capacity themselves and the estate administration isn't complete. That's going to, really add to the complexity of your own estate administration and delay, the time it takes for the beneficiaries to receive what you've left them. So my happy medium would be between 2 and 4, I would say.
Thank you. One for you, Mark. What documents should I keep with my will? And I think this is talking about financial documents. So what documents should I keep with my will?
I think if we're following the process of how to help an executor, I think probably the most comprehensive document that people should look to keep is, where they've took financial advice, really a copy of the financial fact find. That's a really detailed and encompassing document, and it includes, all sources of income, pensions in payment, pensions not in payment, any savings, investments, really anything that client actually had of mine would be recorded on the financial fact find, and policy numbers, things like an audit trail, really, really vital to keep the last certified copy of the financial fact find. I provide people with an annual valuation report, and again, that's a pretty accurate sum total of everything that person actually owned. and it can identify very early on again whether there's a potential for inheritance tax liability just by looking at that one piece of paper. Other documents would be trust deeds, where either investments or life assurance policies were held in trust. It's important to keep those together. As a bare minimum, I guess a business card, giving an email address, a telephone number for the IFA in question. And I think probably lastly, if Sally's clients have got any pens left over, may keep a pen along there as well. But certainly as a minimum, the financial fact find would be a vital document to keep with a will.
Lovely. Okay, thank you very much for that. There's a long one that's come in. I'm just going to read this out, so bear with. It's quite a long question, but this is one for you, I think, Charlotte. I'm an executor for a friend who has a fairly large amount of money, and I'm worried about the fact that I will have to pay the death duties before I can obtain probate. He is currently in a nursing home and has suffered from dementia, and I have power of attorney and have registered this with most of the financial institutions he has his money with. Would it be a good idea to open a joint account with another person with power of attorney and put money in that to cover his death duties?
The crucial thing about that is that power of attorney actually ends on death. So if you act as an attorney for somebody and then they pass away, it immediately comes to an end. You have no more powers as a power of attorney. But it is a good question because it's one that often crops up. People, obviously, it's a big worry to know where inheritance tax is going to be paid from and how you can achieve that as an executor. And there is a bit of a sort of awkward, vicious cycle, because in order to obtain your grant of probate, which is the document that lets you deal with the assets of the estate, you need to have paid HMRC your first instalment of inheritance tax. But you can't actually gain access to the majority of assets until you have your grant of probate, so you're kind of stuck. But there are different avenues that you can explore. So lots of banks and building societies use this direct payment scheme with HMRC. So the executors can apply to them for the banks to use the funds in the deceased's bank account and pay HMRC directly for the first instalment of inheritance tax. And most banks and building societies will do that prior to a grant of probate being issued. You can explore people, perhaps other family members, loaning money to the estate to pay the inheritance tax and they get it back at a later date. Or I know there are external providers that will provide loans to help executors out. And in very extreme circumstances, if you've explored all of the avenues, then you can make a request to HMRC to ask them to waive the first instalment deadline and let you have a grant of probate. But you have to produce quite a lot of evidence to them that you've made all reasonable inquiries and you absolutely, there's no way you can get your hands on any money. Quite often what they'll do if there's a property is place a charge on it, so that they can have some security that they'll definitely get paid at a later date.
Excellent, thank you for that. Mark, one's come in for you. It says, Mark referred to maintaining the ISA wrapper on investments. Can ISA status be maintained if passing assets from parents on death to their child?
Well, kind of nearly, I guess. Historically, what used to happen with an ISA in the event of death was that the tax-free status was lost in its entirety. What's now happened, quite a generous gift from HMRC for a change, is that ISAs are transferable under the additional permitted subscription allowance, but that's from spouse to spouse. And it's really quite generous in the fact that if somebody had got £100,000 in an ISA portfolio and were to pass away, that represents about 5 years of ISA savings, with the annual allowance being 20,000. It would take 5 years to get that back into the system. So ISAs now are transferable between spouse, maintaining the tax efficiency, but not thereafter on second death, if you like.
Excellent, thank you. Another one that's come in. Does the executor need to complete all his duties, his or her duties, within a certain timescale?
That's probably one for me there. So there's quite a big deadline for executors, which is the tax payment. So the first instalment of tax is due 6 months after the month of the date of death. But barring that, there's not many other deadlines in the estate administration that the executor has to stick to. They have a year to pay legacies. So if you have left, if in your will you have £1,000 left to Charlotte Digby, lucky me, then they have a year to pay that to me before interest starts accruing on it. But really, Sally, I could bring you in here actually. You know, there are no set deadlines in which you have to complete things, but if it is dragging on and you're not dealing with it in a timely manner, then you are at risk of beneficiaries wanting to remove you. I think that's right, isn't it, Sally?
That's right. I think you've got to have a good reason why it's taken an extended period of time, because ultimately people lose patience. And I think it's important for executors, so far as they can, to keep beneficiaries up to date. You know, if they can administrate within a reasonable time, then I don't think they need to give that much information to the beneficiaries. But if there's a real stumbling block along the way, then I think it's wise for an executor to let the beneficiaries know, because the last thing you want is the beneficiaries to be seeking legal advice for your removal when there may be a very legitimate reason why you've not been able to move things along as quickly as that you'd like. So I think it comes down to communication, a lot of it.
Absolutely. I think that's a really good answer. Thank you both. Long one that's just come in, so bear with me, I'm going to read it all out. I'm about to update my will. I'm 60, widowed, with no children. I plan to live for at least another 25 years. Pleased to hear that. Should I select an executor from my own generation, but recognise that I'll probably have to update my will again in 10 years' time, or name somebody else from the next generation, but risk the problem that if I die in the next few years, they won't have the time or life experiences to be able to act? I think that's a lovely question, and a hard one for a lot of people to answer, actually. It is that how long am I going to live for kind of question, isn't it?
Yeah, well, so it's the sort of known unknown, isn't it? You don't know when, you know you're going to die, but you don't know when. So it's quite difficult to plan for. But I would say that could you appoint a combination of these people? Because then at any time that it happens, obviously at the beginning I touched on executors having choices. So if you appointed all of these people together and one of them was too busy, they could perhaps renounce or have the power reserved if they didn't feel that they could fulfil their duties and act at the time that you die. Then if you get to the stage where you live your 25 years plus, hopefully, but the other executor appointed is a bit too elderly to deal with it, they also have those options. And then you could perhaps go for someone in between those ages who might have time and be all right to act. So it is a very difficult one, but also you do have, as they alluded to, the option to keep your will under regular review. So you can chop and change people if you need.
I think, sorry to jump in there, Charlotte, but the other option I think is to appoint a professional to be there. Because often, for example, if you were to appoint the partners in a firm of solicitors, it might not be a particular partner, but there would always be somebody there to pick up the job, regardless of the other people named and their own situations.
Yeah, that's a really good point.
That's a good point. Lovely. Another one, I'm conscious of time, we'll probably take 2 or 3 more. It was mentioned that a person cannot act if they are bankrupt. Can they act if they're not currently bankrupt but have been previously? I mean, does that come back to the 6-year rule, Sally? I think that might be one for you.
Do you know, I would have to check the legislation on that, to be honest with you. So you can't be currently bankrupt. It's not something that we come across very often, to be honest. So we'd have to check, but we can check that and get back to that particular question.
Fantastic. Excellent. Is, again, one that we haven't had before, it's clearing the contents of a property when the property no longer belongs to the deceased, a duty of the executor?
So
good questions today.
Yeah, so as an interesting one, I'd love for that person to be able to speak to me because I have some questions. So assuming that the items in that property belong to your deceased person, then yes, you have a duty to dispose of them. personal chattels can be quite a difficult one to prove who actually owns them. If you don't own the property and you don't own the chattel, or your deceased person didn't own the property, didn't own the chattels, then I think you have nothing to worry about as an executor. But if those items belonged to your deceased person, then yes, you have a duty to deal with the personal items. But sounds like if they're in another property that's the deceased didn't own, there's a potential for a dispute there over who owned what, probably, I would say, Sally.
Excellent.
Yeah, definitely. I've got a couple of matters on at the minute where people are falling out over chattels, and largely it's chattels of no value other than sentimental value, and it's a real shame when people have to involve solicitors and spend quite a lot of money arguing over who owns what, especially when, you know, the deceased leaves the chattels to one child rather than another, but the chattels are in a property that is occupied by another, which is an example of one case I've got currently.
The difficulty with chattels as well is you can actually deal with them prior to the grant of probate being issued. So quite often what you find happens is family members who perhaps aren't executors or friends and other relatives might actually go into a property and take them and deal with them prior to the executor's involvement, so right at the very outset, which then can again cause a lot of problems for the executor. Because more often than not, someone then says, oh, where was that, you know, grandfather clock that I rather liked and I thought I was going to get, and it's been dealt with before executor's involvement.
Absolutely, thank you for that. And I think the final question we'll have for today, can executors claim expenses and what is deemed as reasonable?
Okay, I'm happy to take that one.
Thank you, Sally.
Yes, executors can claim expenses. What is reasonable varies in each case. It depends what steps need taking within the estate administration, or the usual things that you would expect in terms of legal costs and other disbursements in relation to sorting out the estate. I think are absolutely fine and reasonable. You do have to be careful, because ultimately as an executor, in terms of the expenses that you've claimed, you're answerable to the residuary beneficiaries. So they ordinarily at the end of an estate administration will receive a copy of the estate accounts. Within the estate accounts, it will list the expenses claimed by the executor, and you need to answer to them if they query them why they're justifiable and reasonable in terms of your job dealing with the administration.
Excellent, thank you. And thank you, panel. So I think that sums up today. I'm conscious of time. Hopefully you found today informative and useful. I think today has shown the importance of ensuring that you have a plan, it's regularly reviewed and it's up to date. We'll be sending out an email after today's event with the video link on of the recorded webinar, so you can watch it again or share it with family if you like, so do keep an eye out for that in your inbox. The email will also include a link where you can provide feedback on today's webinar. We'd love it if you could actually spend 2 minutes and just send us some feedback. We're really keen on doing these and helping our clients, so any feedback is really valuable to us. If you wouldn't mind, it helps us improve our future webinars. And if you'd like to talk to somebody about either making a will, appointing an executor, or are interested in taking financial advice, again, please reach out to us. The email being sent out will include contact details on how you can get in touch. So once again, thank you very much for joining us today. I hope you've enjoyed it, and from myself and the panelists, goodbye and thanks again.
Thank you.